Corporate Theft from the Public, Consumer Fraud. Module 4, Readings Part 2. The history of consumer rights standards, in its modern form, is quite recent. In much of the 19th and early 20th century, the original legal doctrine was so-called freedom of contract and caveat emptor, let the buyer beware. But a series of crises eroded that doctrine. The 1905 novel, The Jungle, which highlighted both the abuses to workers, but also the contamination in meatpacking across the country, led to an increase in meat inspection and the birth of the Food and Drug Administration. The Progressive Era and then the New Deal led to new regulatory agencies and laws on consumer protection. John F. Kennedy talked about a consumer bill of rights, and Ralph Nader and other advocates highlighted unsafe products getting to consumers. The Federal Trade Commission has become the main federal institution dealing with consumer harm. It's an independent agency with 5 Senate-approved presidential appointees, 3 from the president's party, 2 from the opposition. It has a focus on antitrust as well, but the Bureau of Consumer Protection focuses on those consumer rights. Its authority comes from Section 5A of the Federal Trade and Communications Act, which prohibits, quote, unfair or deceptive acts or practices in or affecting commerce. There's also authority for the FTC under 46 other statutes, including Truth in Lending Act, Fair Credit Billing Act, Fair Credit Reporting Act, and continuing enforcement of industry-specific acts, such as the Petroleum Marketing Practices Act. The FTC can use the courts to seek civil penalties and restitution for consumers who are harmed, but it refers criminal charges to the Department of Justice. There are other key agencies for consumer rights as well. The U.S. Consumer Product Safety Commission. It's the agency with the mandate of reducing injury or death caused by consumer products. The U.S. Food and Drug Administration, the FDA, focuses on food, drug, cosmetic, and medical device safety. The National Highway Traffic Safety Administration covers automobiles, truck, and motorcycle safety. The Federal Communications Commission, FCC, has broad jurisdiction over broadcast communications, communication common carriers, and it resolves consumer complaints regarding those kinds of communications services. And there is the newer Bureau of Consumer Financial Protection, created by the Dodd-Frank Law in the wake of the financial crisis a decade ago, designed to regulate and oversee financial services aimed at consumers. One of the big areas that people look at is consumer credit and debt collection and the abuses that flow from that. Until the Fair Credit Reporting Act, FCRA, was passed in 1970, consumers could not easily confirm the accuracy of the information being used to grant or deny them credit. In 2003, FCRA was amended to ensure American consumers could get annual access to a free copy of their credit report. Congress also passed a Truth in Lending Act, which standardized credit disclosures to make it easier for consumers to comparison shop for better credit opportunities. Fair Credit Billing Act created procedures to require creditors to promptly process billing disputes and correct them. And there was the Fair Debt Collection Act, which was designed to prevent the abuses by debt collectors that had become all too common, to prevent threats, profanity, lies when attempting to collect from debtors. Collectors are limited to contacting a debtor during reasonable times of the day. And there's the Credit Card Accountability and Responsibility and Disclosure Act of 2009, which further expanded protections for consumers from abusive practices by credit card issuers. Then you have the state mechanisms for consumer protection. Much of those state investigations happen through the attorneys general across the country. AGs are responsible quite often for state consumer protection laws in most states. And under a number of little FTC acts, each state AG has statutory authority to seek injunctions to remedy unfair or deceptive trade practices. Now, there are different regulatory structures in different states, so the rules and who has responsibility for enforcement may differ across the state. One of the key areas is private right of actions for consumers, where they can directly sue companies that have harmed them in some way through bad products or fraud. Now, at the federal level, there is no private right of action under the Federal Trade Act, but state laws normally allow consumers to sue for damages and injunctive relief. These are often put together in class action lawsuits, where victimized consumers who have suffered each only a small harm can collectively sue, although courts have made these collective lawsuits far harder in recent years. Laws in many states allow consumers to pay their attorneys through fees collected from the defendants when they win. 49 states use the framework of what's known as the Uniform Commercial Code to protect consumers through express and limited warranties that make sure that for some period after they buy a product, they can get a refund if it turns out to be damaged or otherwise not living up to expectations. There are also what are known as unfair and deceptive acts and practices statutes, adopted largely in the 1970s and 1980s to protect consumers against direct consumer fraud and abuse. These state unfair and deceptive acts and practices statutes in practice differ wildly in different states. They're primarily civil statutes. Some allow criminal penalties for extreme violations. The goal is to stop abusive lending, bait and switch tactics, where you promise one thing and give another, and outright deception. They often address harassment, high-pressure sales tactics, one-sided contract terms, and they give a number of different relief. What's known as equitable relief, which is an injunction or order requiring a business to stop engaging in an unfair or deceptive practice. Restitution for consumers, requiring the business to return money that was wrongfully taken from consumers. And quite often a civil penalty, a penalty imposed for having engaged in an unfair or deceptive practice, usually paid to the government. Some of those penalties go as high as $40,000, but others may be as low as only $1,000. There are a number of weaknesses in the unfair and deceptive acts and practices statutes. For example, Missouri and Rhode Island. The courts there have interpreted the statute as being applicable to almost no consumer transactions, making the laws largely useless. Louisiana, New Hampshire, Virginia, they exempt most lenders and creditors from UDAP statutes, while another 15 states leave significant gaps. Insurance companies are exempt from UDAP statutes in 24 states. Utility companies in 16 states are immune from UDAP laws. And Alabama and Florida exempt all banks, regardless of the unfair or deceptive nature of their acts. And laws often prohibit only deceptive acts, while unfair acts, one-sided approaches, other kinds of unfairness are often not covered. And there are weaknesses in the remedies consumers can invoke, such as failing to allow consumers to recover attorney fees in many states. In your reading, gave one recent example of a wide-scale fraud at Wells Fargo. This law highlighted the weakness of consumer fraud enforcement. In this case, there was a system of company-wide quotas, incentives that pushed 5,300 employees at Wells Fargo to illegally open new accounts without consent, driving overdraft maintenance fees for consumers who never thought they had opened an account. The Consumer Financial Products Board fined Wells Fargo $100 million, plus $85 million for other authorities. But this was just 3.3% of the $5.6 billion in net income Wells Fargo pulled in the second quarter of that year. and the Department of Justice is unlikely to apply criminal penalties. And this is a problem. There's little history of applying criminal sanctions against even the largest scale consumer fraud, no matter how high the level of theft. In all these cases listed, not one single individual spent a single day in jail for the criminal activity that justified those monetary penalties.